Alright, so today I'm going to tell you that 100% for and beyond all reasonable doubt that I'm mostly positive and pretty sure that shopping at only tactical fans at Shopify.com will make your life better. If not, then demand a refund from Trump. He's got your back. Alright, this is the fifth and final segment about my husband's appeal. And once again, these are standalone segments, so no worries. If you've missed it, you can watch previous videos in the appeals playlist. So, several people have asked why in this shit haven't my husband's... Oh, look who it is.
Matthew Hoover.
Substance call, press 5.
Gorgeous, what you doing?
Just waking up.
Oh, I thought... I got a message from you like an hour ago, so I thought you were awake.
I'm just kidding.
Well, I just wanted to thank everybody for supporting us, because honestly, if it wasn't for you guys, we would have lost everything. I don't think I could have done it without your guys' support, so thank you. I really do appreciate it. So anyway, one of the newsletters I've subscribed to from the lawyers, looks like 1B1-3 might be taken away from judges.
What's that?
That's what they use to enhance me. So if that goes away, then I come home. I don't know if it will or not. It looks like this case is called CARLTONW I don't know. The point is, it's one of the things they're looking at right now. But yeah, the 1B1 is how she took me from what should have been 18 or lower to 30-something.
I thought that was like the K or the K2 or K1 or whatever it is.
No, that's if you ran on someone.
Oh, yeah. You definitely did not do that.
No. No, this is what you used to enhance me.
And so, yeah, but does that mean that, like, prior cases, they get adjusted?
Yeah, it would be retroactive. I just want to tell you, like, that's how quickly shit's changing. So I really don't think I'm missing my whole sentence, even if I don't get my acquittal.
I mean, I hope so, but, babe, my feelings, yeah.
Because I'm subscribed to a bunch of lawyers' newsletters. So, like, when you send me a message, I also get messages from lawyers on there.
Oh, okay.
But alright, I love you.
Alright, love you too.
Bye.
Bye. I just love hearing from him. So several people have asked me why in the shit haven't my husband's lawyers applied Bruin so his charges would be dropped and he could come home. Well, they did. Or they attempted to anyways. But the judge shut it down because Bruin is so new, it flipped the means and end scrutiny upside down, which was the case law the courts were using since 2008. In my opinion, the judge panicked because she's been taught over years that common men are not capable of possessing certain types of firearms and need to be locked up if they do. Then Bruin comes along requiring judges to no longer follow their emotions and now apply the Second Amendment as written. Although I do feel like a lot of times they definitely do use their emotions, especially in this case. Now this is a little bit above my pay grade, so I'm going to let the lawyers explain it and I'll just read from his appeal. And don't judge me, we all know I'm bad with words, so I'll try to get them right, but if not, it is what it is. And at least put it on the screen so you guys can read it. So, Mr. Hoover raised as applied Second Amendment concerns at several stages of his proceedings below. The district court denied these motions and entered a final judgment terminating the claims of the parties. The Supreme Court landmark Bruin case came down during the course of the proceedings below, which finally laid out a clear legal standard of the evaluation of acts regulating the peaceable keeping and bearing of arms. Bruin identified the courts of appeals, coalescing around a two-step framework from analyzing Second Amendment challenges that combines history with means and scrutiny. The court identified this as one step too many. Bruin articulated that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that an individual's conduct falls outside the Second Amendment's unqualified command. As Mr. Hoover predicted in his motion to dismiss the indictment, the government attempted to argue that machine guns are beyond the scope of the Second Amendment by attempting to characterize them as dangerous and unusual, as it has in other cases, but this is not the test. The courts often misunderstood invocating of dangerous and unusual weapons itself as reference to the Statute of Northampton, which merely forbids the carrying of such weapons in a particular manner in Heller, and subsequently Bruin was for the purpose of discussion of what might be a constitutionally acceptable law rather than the endorsement of any particular extent policy. Indeed, it is clear that the Heller dicta misconstrued by the government as a test was simply the court cautioning that it was not undertaking an exhaustive historical analysis of the full scope of the Second Amendment. Even so, the government refused to engage in a historical analysis, instead relying on pre-Bruin decisions and misconstruing Heller's dangerous and unusual dicta as a test. The district court refused to apply the Bruin standard, instead holding that the Supreme Court's holding in Bruin did not overturn D.C. versus Heller, in which the court recognizes the importance of the historical tradition of prohibiting the carrying of dangerous and unusual weapons. The issue of the Second Amendment is made difficult by the district court's refusal to make the legal determinations discussed above. The key question under Bruin is whether the regulated item falls within the unqualified command of the Second Amendment, whether it is an arm. Arms as contemplated by the Second Amendment are not limited to firearms or offensive weapons. The Second Amendment implication hinges upon the answer to the legal question of whether or not it is within the purview. Appellate contends that it is not, but if the court finds otherwise, then it's necessary because as arms, thus falling within the Second Amendment's unqualified command. The district court short-circuited the Bruin test as relied on pre-Bruin case law, applying means and scrutiny in exact contravention of Bruin. Whether or not the AKC was a weapon, whether or not it was a machine gun, whether or not it was a combination of parts, and whether or not whatever it was, dangerous and unusual, are questions of law that the court failed to address. Even in reliance of the pre-Bruin case law, the district court exclusively relied upon cases where whether or not the charged item was a machine gun was not in question, while substantially submitted the legal question of whether or not the AKC was a machine gun to the jury. It cannot stand that district court could relieve the government of its burden under the Bruin by presupposing that in an as-applied challenge, the conduct simply fell beyond the scope of the Second Amendment without engaging in the requestable analysis. Whew! That was long. Oh my gosh, I'm sorry if I botched some of that. Now I understand that it was kind of dry and fucked, but sometimes you just got to muster up some spit and push it through it. And that's what we did. I still can't believe what happened. I still can't believe that I'm even up here doing this, although like I can, but I can't. Like, you know what I mean? I definitely realize how strong of a bitch I am. I don't think I give myself credit enough of it, but it is what it is. But yeah, I hope you guys like this, and if you did, give it a thumbs up, comment, like, and subscribe. And also, if you'd like to continue to support the channel, don't forget to shop at onlytechnicalfans.shopify.com. And also there'll be like Amazon, Patreon, PayPal, Givesendgo, all that stuff. It all goes to helping fight against the government for my husband, me to travel to see my husband, my bills, my kids, everything. So I really appreciate it, guys. And until next time, peace. And subsequently, it cannot stand that district court could. It cannot stand that the district court could. It cannot stand that the district court. It cannot stand that district court. It cannot.